Hi, everyone. This is Matt with ESI Survival Guide. We're here to help all you legal professionals out there navigate the electronic wilderness. And first and foremost, let me thank my guest, Doug Austin. Doug, how are you?
I'm great, Matt. Good to be here. Good to be here for your first interview of 2023, right?
Exactly. Not just my first interview of 2023, but I took a bit of a hiatus, I guess you could call it. This might be the first session I've done since last April. I think the last one I did was on electronic nudges, and that's because new job, move, lots of new things and very positive things in life. But I thought, Doug, how apt is it that after taking off, like, what is that? At 8 months from the podcast, I would interview the guy who hasn't taken a day off in 114 years. For those of you who don't know Doug has been doing a daily eDiscovery blog since I think, and despite he's much younger than this, that there's a kind of maybe some vampirism going on there, about 1914, right? Is that the...
A little off, maybe more like 2010, but close enough within the same 100-year stretch. Yeah, so there you go.
Can I ask you a question? How, outside of amazing time management, you are definitely the most prolific blogger in the space, and that notion that you haven't taken a day off in as many years, I got to ask you, how do you do it?
Well, it's... For starters, it's not just me. The eDiscovery today has really become a crowdsourced blog in that it's a lot of the content is partner driven. I cover partner content for my educational partners. So they may write things, I may then cover them. So I'm writing a post to a degree, but they're providing the original educational material. So it's not something I think any one person could do anymore. And that's one of the things I think eDiscovery today is continuing to be more about, is really trying to be a crowdsourced resource in the industry.
So eDiscovery today, one of the most aptly named blogs. It's not just kind of a colloquialism. Literally, it is eDiscovery today, every day. And one of my buddies actually had a blog that he ran kind of in combination with being an adjunct professor of eDiscovery at a law school. And I always thought he had a genius way of making content concurrent. He made it essentially homework for his law students to write entries into his blog. So, but
there you go. Hey, I've thought about that at times. It's like, hey, how can I get some other help in here with this? But yeah, I'll take, when you're writing a daily blog, you're looking for any way to get content you can. So, and I kind of joke that my motto is ABC, always be contenting, because it seems like that's what I'm doing all the time.
Sure. And not only is it awesome to have you on the podcast in terms of me coming back and relaunching and having someone as prolific as you, but also the topic I think is perfect, because we are going to be covering your 2023 State of the Industry report. And what better way to kick off the relaunch of the blog, but also the year, by talking about some industry trends. And Legal Week is a little bit later than normal this year in March. And I think in the lead up to Legal Week, what better topic than to talk about some trends? But Doug, before I jump in, I got to give the disclaimer. So the thoughts, opinions, beliefs, everything that we express are those of ourselves and not necessarily the opinions, beliefs, thoughts, or comments of anybody else, our respective partners, employers, or anybody of the sort. So, and if you need any legal advice, this is not meant to be legal advice. This is simply educational content. If you got to talk to a lawyer, go talk to a lawyer, especially if it's applicable to a certain set of facts. So with that disclaimer, and you can see I'm already a little rough. Go back to my last podcast, and I was probably able to rattle that thing off perfect.
You did great.
So, and not only that, but I was telling Doug in the pre-interview, Murphy's Law, I have these super fancy headphones that I bought just for Doug and the relaunch, but of course they crapped out seconds before. So I have my son's trusty headphones on. But anyways, let's go ahead and jump into this. And one of the things I want to do, and usually I don't use reading aids, if you will, but this report is so robust, if you will. There's so much depth to it. And I've read this thing maybe 100 times. So I took a lot of notes, but I would implore everyone, and we'll include the link, go download the report and read it yourself. And I encourage you to use it as a point of conversation with your colleagues. I definitely have done that. And I think the trends that we're going to discuss today are definitely ones that have been applicable in the past, but it's really cool how they've developed over time. And I think, Doug, what's cool about the 2023 report is there's a lot of new things going on with this report. So before we dive into the actual report, how many years have you been doing the report? And can you talk a little bit about what birthed it and what really the goal is with the report?
Yeah, absolutely, Matt. So this is the third year of the report, and it's a report I just kind of thought about, and I reached out. EDRM is a foundational partner of eDiscovery today, so I reached out to Mary and Kaylee of EDRM and kind of said, "Hey, I want to do something a little bit different. I want to do a report that's based on a survey, but also has a second component, which is thought leader observations about some of the same topics. So it wasn't just a survey result, but it would be a cross section of thought leaders as well." They really liked the idea, and I put together a draft set of initial questions for that first survey a couple of years ago, worked with them on kind of refining it, and we launched it. And the first year we had 183 respondents to the survey. Last year we had 281, and this year we had actually 410. So year over year, the breadth of the survey responses have been growing about 50% each year, and that's been the same as well for the breadth of thought leaders included in providing observations as well. So it's continuing to be more of a broad, hopefully a broad reflection of what the industry feels about these different e-discovery topics.
And definitely over the years that I've been reading it, what's also, I think, been interesting is the demographics of the report and how those have changed. What in terms of the survey responses, what are the categories of the demographics? And can you tell us a little bit about the categories of folks that have been responding to it?
Sure. So we have pretty much what you would expect to be the typical demographic groups that you would include in an e-discovery survey. So that would include law firms, corporations, software and service providers. We have as a category consultancy groups. We also have government agency folks, and then of course miscellaneous, which could be media and so forth. What we've done all 3 years, in the past 2 years, we've actually been able to have enough respondents to break out 4 of the groups. We've had breakouts for corporations, law firms, software and service providers, and consultancies. So not only do you get the overall response to a question, but you get the individual groups breakouts on that. And sometimes they're very similar, and sometimes they're very diametrically opposed, which makes for interesting results as well.
Do you envision there being a time, I know from working with a service provider, and just to give a shout out to Concilio, and not just to do the brand recognition here, but also, Doug, you gotta.
I do have my Concilio cup that I got last year from Canaan at the University of Florida conference. So just happened to be drinking it out of it today. So
We did not plan.
I did not plan that. It just happened to be there.
So shout out to Canaan, who probably everybody watching this knows, great man, and shout out to Concilio. But
yeah, great guy.
And looking at the demographics, do you envision, and again, from a service provider standpoint, all of those individual demographics, I often break down. You break down firms by the size, region, by practice area, corporations, the vertical that they're in, of course, have widely different obligations in this realm with technology, e-discovery, whether it be pharma, finance, consumer goods, insurance. Do you envision a development over the next few years of maybe having breakdowns along those lines, or is that going to be something you think is too granular?
I think it's too, I've kind of taken the approach with the survey and the report that kind of adopting the KISS principle, keep it simple, stupid. And part of that is it's a lot of work to even break it down to this level.
Sure.
So breaking it down even further would be more work. It's already a pretty big report because this year's report was 45 pages,
Yeah,
which is hard not to be when you're breaking down the stats and you also have 2 to 3 pages of thought leader observations about each of the sections as well. So it's kind of one of those deals where I think I'm going to try to keep it at that same level. I'm hoping next year we'll have a large enough group of government agency respondents that we'd be able to break out a 5th group,
Sure.
which would be great. I didn't feel like we were quite there this year, but that would be probably the one additional breakout I could see in the near future.
And not to blow smoke, but one of the brilliant things about the report, I thought, is having that thought leader breakout, because although maybe the overall trends and the graphs that you use, and we'll put some of these up on the screen, but maybe some of these graphics and kind of the larger trends, having the thought leader quotes in there allows for individuals to dive more deeply into specific areas. So if there are like certain nuances that might be applicable to some of those more segmented groups I just mentioned, a lot of that comes out in the thought leader chatter, which I thought was really cool. And we'll talk about some of that. And again, the comments run the algorithm on YouTube. So feel free to please comment, like, subscribe, but comment will be great. And Doug and I are going to open up lots of opportunity to comment when we start talking about the individual questions that those thought leaders addressed. But let me jump in with one more general question. I'm going to put these up on the screen, but there was 8 core components of the survey, or kind of categories of questions, if you will. Remote versus in-office work, in-person legal technology conferences, so whether people are going back to conferences or not, the use of predictive coding, data from mobile devices, data from collaboration apps, use cases for eDiscovery, the biggest eDiscovery tech trends of 2023, and then what's the challenge in eDiscovery that's not being talked about. Doug, what was the impetus behind these categories? Were there any categories that you left out, or were there any that you wanted to put in, but again, it was just maybe too much to put in?
So we toyed with the idea this year of making it, so it's a 10-question survey. The first 2 questions are demographic questions, and then those 8 categories you just mentioned. We toyed with the idea this year of making it a 12-question survey, but we just kind of felt like a 10-question survey is quick and easy to complete. And
10's a nice round number, right? It sounds.
Yeah, it's a nice round number. Not saying we'll always keep it there, but we're going to probably not grow any more than 12 at the most, if we ever do. I will say for this year, we did replace one question with a new question. In previous years, we've asked what's the biggest eDiscovery business trend of the year? But we decided to boot that question because year over year, it's probably not going to change that much in terms of what people think. Also, Rob Robinson does a great job of business-related surveys on Complex Discovery, his site. He does this quarterly eDiscovery Business Confidence Survey and things of that nature. So he's got eDiscovery Business cornered. So I felt like that's probably a question he's already addressing. And one of the things that I started thinking about is we talk all the time about eDiscovery being useful for more than just litigation. But I wanted to see this year with the new use cases question, just how many other use cases they're using it for. And that was one of the more interesting results of the survey, was just how many people are using it for so many other use cases.
I would agree with that. eDiscovery is definitely not for just eDiscovery anymore. I almost think we need I use the term legal technology or even data law to kind of try and be more encompassing, although it's not a totally accurate moniker, but I try to be a little bit more broad in how I talk about it. But so let's go ahead and jump in. So the first one is about the return to work. And I think whenever we talk about trends in terms of COVID, and how that's impacted the industry. Of course, the reason we're all remote is kind of birthed from that whole issue. And I know personally, this is my office. I changed companies during the pandemic, but I still am almost wholly remote. Now, as an attorney consultant on the service provider side, that's kind of easy, if not beneficial for me. And in some ways, I miss the whole, if I have an issue, I can walk and talk to somebody to their face, the kind of team camaraderie around vendor work, which is inherently very team-based. Although on the business development side, that can be kind of a lone wolf thing in many regards, although at Concilio, it's very team-based, but I'm traveling a ton. I'm flying all over the place, in-person meetings and whatnot. I'm shocked about how many folks are taking in-person meetings, but I think, Zoom fatigue, as people talk about, really helped to precipitate that. What were the trends that you saw come from the survey with regards to across those demographics? Who's going back to work and who's staying remote? And do you think that that's going to stay static in that those categories for a while?
Great question. And first, I would say, so this question's evolved over the 3 years because obviously we've evolved in the pandemic. And as you can imagine, the results have evolved as well. Last year, I think we were still kind of coming off the Delta variant. We were in the midst of the Omicron variant, and a lot of people were still hesitant about return to work and return to in-person work. And so I think we were around 90% in terms of people who were working mostly remotely last year. This year, it's more like 60%. So you're certainly starting to see people come back in either a hybrid or mostly in office work environment. But the demographics of who's doing it is pretty diverse. From a corporation and law firm standpoint, you're seeing them come back at a much greater rate into the office than you are service providers and consultants. So I think that is interesting in a couple of respects. Certainly, one of the things you could explain as part of that reason is, hey, the corporations and the law firms, they have the expensive offices. They kind of need to make use of them. And why wouldn't you kind of say, hey, it's time to get back in? But I also think that it's also a little bit of what groups have been used to. One of the things that was surprising about last year's survey is that there was a significant percentage of people who are already working remotely before the pandemic even began. And that was highly concentrated, especially in the service provider or the provider and consultant area. So these are groups that have already been kind of used to working remotely. And yeah, they may do some hybrid here and there, but there's a lot of service people who are working remotely day in, day out.
Sure.
So I think that's one of the things that is notable, is that it depends on the group you're in. I think it's 6 out of 10 corporate respondents have returned to the office either full-time or in a hybrid mode, and almost half of law firm respondents have, but almost 73% of providers are still working mostly remotely. So,
Sure.
and even a higher percentage of consultants are working mostly remotely. So those are, that just kind of illustrates how diametrically opposed those two sets of groups are.
Yeah, and it's also interesting how the whole nature of remote work forced a lot of trends in the eDiscovery world in terms of the services that are provided. Like, there was often a time where when you were doing forensic collections, folks really wanted to have that technician in the room or in person. And there's still a lot of technical reasons why you might want to have that. But now you see remote collections happening more and more. Same thing with review. I would basically venture to say confidently that very few vendors that offer managed review are doing the majority of their reviews in their data centers. I think most folks are doing secure remote review at differing levels of service, but they're trying to do that. And the positive, I think, there is that you maybe can pull from a wider talent pool, if you will.
Absolutely.
At the same time, though, I think you sacrifice a little bit of the unity. I wanted to read one quote from the thought leader section. Mandy Ross, who's the founder and CEO, managing director of Insight Optics. The question that was attached to the remote versus in-office work question in the survey, Doug, that you asked was, how do you think the COVID-19 pandemic continues to affect the legal profession, if at all? Mandy's response was, in the context of eDiscovery and litigation, the continuing trends around working remotely have created a more divided and decentralized dynamic among corporations, their law firms, and service providers. The use of technology to facilitate centralized collaboration and tracking in relation to all the stages of the litigation lifecycle is critical to ensure that processes are being handled in a timely, consistent, and defensible manner. Would you agree with that statement? Do you think that, I guess I'll put it in a simple kind of one sentence form. Do you think that the pandemic forced adoption of technology in a way that you think is here to stay, or do you think there's going to be somewhat of a fallout from that?
No, I think it's here to stay. And I mean, you don't have to look any further than the platform we're on right now, Zoom, because everybody, had to learn how to use it once the pandemic started. And, I've reported on this stat many times. Back in December 2019, pre-pandemic, Zoom had about 10 million daily users. And by April, they had 300 million daily users. So they had a 30 times growth in about 5 months when the pandemic hit. And now everybody, even people who are not technical, have had to learn to use Zoom because you almost have to invariably meet with people online, no matter where you're located. So it's become a standard that people have had to get under their belt, and they did it quickly. I don't think that's going away. The only question will be the volume of online meetings we'll conduct, not whether we'll conduct them.
Sure. And one interesting thing with Zoom, and I do want to highlight the fact that with every question or core category in Doug's survey, there's this interesting little tidbit, factoid, if you will, that can lead to further study. The one here, and again, I'm not going to answer it. I'm just going to put it out there because you got to go to the survey, read the survey, and click on the link. But Zoom video conferencing may now be a common way to meet with other remote employees, but it's not considered a place for purposes of conducting a deposition. And then, Doug, I assume that link is to a case, right?
It is. Actually, we just talked about that case yesterday on the monthly EDRM case law webinar. It's interesting because there are rules when it comes to place of deposition where it's being conducted. And the particular party tried to say via Zoom video conference. And the judge in the case actually quoted MC Hammer and saying, that because it was about jurisdiction and whether he could rule on it being there. And he said, to quote MC Hammer, this court can't touch this. Saying that I can't force them to conduct the deposition this way. So,
Doug, I was hoping you were going to say the judge said I'm too legit to quit.
Right. Well,
The
yeah, we probably should have thrown that one into the mix yesterday when we were throwing out MC Hammer puns. But yes, that's one of the things I try to do in the report is link to things that have been covered throughout the year as well that can provide additional information. So
and Zoom, to anyone who's a YouTube fanatic as I am, Zoom has opened up the door to a lot of very interesting legal-based YouTube channels that focus in on Zoom hearings. There's a lot of interesting things that have developed on that front. But so if I could say the takeaway of how COVID has impacted kind of the remote work environment, that remote work is here to stay. We're seeing maybe a trend up in the hybrid realm, but definitely if we were going to put in office to remote work on a spectrum, it kind of begins with the corporation on this side. They're kind of the folks that are going back the most, law firms, and then we get back into vendors and consultants. They're probably more remote.
Indeed, I would say. And I also think that there will probably be some pressure on the corporates and law firms to continue to offer some remote capabilities because, I think that I think a lot of the surveys I've seen, people like working remotely at least a lot of the time. So that's one of the things I think we'll see happen is there's going to continue to be pressure. Last week at the University of Florida conference, Jared Casiglia of Through Staffing talked about the lead time for hiring, and it tends to be higher for the law firms and corporations. Well, I know he specified law firms specifically versus providers. And part of that is the whole aspect of the being in the office versus being remote and so forth. So I think there will continue to be pressures for there to be some level of remote work across the board.
Sure. I also think the last I'll say about it before we move on to the next category, I think it pushed a lot of people emotionally into a space where they were more willing to, I don't know if the right phrase is stick up for themselves, but they were more willing to draw a line in the sand about what matters to them. And I think because you saw a lot of people who never in a million years would have made work from home versus go to an office kind of the line in the sand they would draw for their career. But I think you saw a lot of folks who, whether it was motivated more by work-life balance or kind of focusing on what's important, that really did draw that line that I want to work for a company that offers this benefit. And I'm willing to make a change based on really that fact as a priority, which I thought was pretty interesting.
Sure. A year ago, we were talking about the Great Resignation, and a lot of that was factored by that was influenced by the remote versus in-office decision as well, no doubt.
Moving into the next category is kind of a corollary, if you will, to the remote versus in-office work is in-person legal technology conferences. What was the question that you were asking around conferences, and what were some of the high-level trends you saw from the responses you got?
So that question also evolved over the past 3 years. Obviously, when we started the survey, and we were in the midst of the pandemic, and people were really doing almost totally virtual conferences, we were talking about the value of virtual versus in person and so forth. Then last year, we were starting to ask people, did you attend any conferences? Because there was starting to be a little trickle of in-person conferences over the course of the year in between kind of variants of of COVID-19. This year, it seemed like, at least for some people, we were back in full in conferences. So the question became, are you attending as many legal technology conferences as you did before the pandemic? If not, why not? And actually, more than a third of respondents, 34.1%, said they attended as many conferences as they did before the pandemic. And nearly three quarters, 74.5%, attended at least one conference last year. Only 10.8% said they didn't attend one last year and at least aren't sure about attending one this year. So we're seeing that move back to in-person conferences, certainly in a big way. And the reason that people might not be going to conferences isn't so much about COVID anymore. It's actually about the expense of going to the conferences. So I think that's one of the things that's, now we're dealing with. Travel costs are higher, the economy, everything's more expensive, and companies are having to make that decision of, the ROI and is it worth going and so forth. So that's really, it seems, more of a factor than concerns about COVID.
Sure. And I think in terms of looking at the thought leader quotes, this was one where it was pretty diverse. There was a wide berth of folks who thought that conferences were not back to their pre-pandemic levels, and some folks that thought they definitely were. One thing I thought was interesting, though, was that service providers, the folks that are most likely to work remotely, were the category that were returning to conferences in the highest numbers. I'm assuming that's a function of typically at conferences, that's the primary place where they do business and sell and engage the community. But I thought that maybe they're also just the biggest partiers and they wanted to get back to hanging out with them.
Of course, that goes without saying. Yeah, absolutely. No, I think the exhibit hall is full of providers who have booths and are looking to try to get name recognition and really move business along and so forth. So yeah, 4 in 10, I think it was nearly 4 in 10, over 4 in 10 provider respondents attended as many conferences as they did before the pandemic. One of the more interesting, so again, a little bit of kind of divergence, corporations, it was only 20% attended as many conferences as they did before the pandemic and plan to do it again this year, which of course has got to be concerning because they're the ones a lot of us are selling to, or a lot of companies are selling to. So again, it's not so much based on concern about COVID, because obviously they're going back to the office in droves, but they're not necessarily going as much to the conferences. So for them, the ROI is, I think, a little bit more hit and miss.
And if I could give a shout out to two individuals who have widely differing viewpoints on this. One, Darius Bennett, who Doug responded to the thought leader section, who's the principal of Darius Emeka Bennett. And he basically said that he does not think things have returned to pre-pandemic levels, that people still have a little bit of shell shock. Whereas Robert Keeling, who's a partner at Sidley Austin and the co-chair of Sidley Austin's eDiscovery and Data Analytics Group, he said, this year seems like the year that conferences returned to pre-pandemic levels. So I think that could be a function of the conferences people attend, but also what I thought when I read this, this category and this question, I thought an interesting secondary question would be, have you had COVID? And I'm wondering if folks that had already maybe experienced COVID were maybe a little less trepidatious about venturing out into the conference world. I, for one, had it 3 times, if you can imagine.
Wow.
So I'm hoping that that's a good sign that I have antibodies and not that my immune system is maybe needs some work. But I do wonder to what extent that seems to be a very loaded question that's really based on almost how you feel about transmission and the pandemic more generally.
Mm-hmm. I do think there were certainly some people I know in the industry who were still reluctant to go to conferences last year because of the lingering COVID concerns. And I think that might be reflected in some of the thought leader responses. But I attended I attended a couple of conferences last year, ILTACON, which was decimated the year before because their conference was right in the middle of the height of the Delta variant, and they just had a small subset of people who normally show up in person for it to show up in 2021. Last year, they had a record number. They actually had to turn people away. They had over 3,000 people at the conference, and they were fully back. So that was an indication that people are going to conferences again, and maybe obviously, as is what always will be the case, there'll be some that may be, still not quite there ready to do it. But I think we're beginning to see that the reason they're not doing it is not necessarily because of concerns about COVID anymore, but concerns about the cost and the ROI. And I think that's a battle, that was one of Tom O'Connor talked about. The enthusiasm to go is there, but not necessarily the enthusiasm for the employers to pay for it. So, I think that's going to be the question that will be more of a consideration.
That's a really good point. And one of the things too, I think is also interesting is that the conference experience, I think, has changed remotely. I know that, and being a part of trying to build conference experiences on the provider side, you do really try to get creative in terms of how do you keep people online? How do you keep people engaged? Right. I think a lot of this might be that there's an element of people or a group of people that may not have ever really gone to conferences, but now they're really engaged because they can do it in the comfort of their own home. So maybe that's a growing aspect of this too, is that people are attending remotely, not just because of COVID, but because they can, and they can get the same or a similar experience, if you will, remotely, which really wasn't. I mean, imagine attending Legal Tech remotely in 2015 or 2010 or even 2018. Could you? I mean, I didn't even know if there was an option.
No, well, and so one of the interesting things about conferences is some have gone fully back to in-person only, and understandably, because that's really their revenue model. I mean, they make their money with people there at the event in person, going to the sessions, going to the exhibit halls, and so forth, and that's really their revenue. So I can understand why some aren't offering a virtual option. Others are. Last week, University of Florida conference, they don't have a very big venue, so they can only support about 220 or so people there in person, but they had another nearly close to 3,000 online. Wow. So, it was, I think it depends on the conference and what they, look to do there. So I think that you're going to have some conferences that are going to stick to in person because that's how they make their money. It is as simple as that.
Well, kudos to you and shout out to Bill Hamilton and folks. I know that the Florida conference was a really good one. I was going to ask you the conferences that you enjoy the most throughout the year. I'm assuming that the U of F one is one of them. What are your other, give me another one or two highlights of your conference season that you're now excited to go back to, that things are opening up?
Historically, for me, Legal Week and ILTACON have been must attends. Those are two that are always on my list. This year, I'm going to try to attend the Clock Conference for the first year because it seems like that's become, legal ops and eDiscovery have become a lot more intertwined, and it seems like there's a real focus of eDiscovery and the related technologies there. So I think I'm going to try to go to that one. And then the other one that has several events, local events throughout the year, is the Masters Conference. And I'm going to look to attend a couple of those as well, at least a couple of those. They've got one coming up in Dallas in about 2 or 3 weeks, I think, and so forth. So those are ones I try to put at the top of the list, and then one or two others that make that I may wind up going to, depending on circumstances.
I was at the Atlanta Masters Conference, which was great, and registered to go to a couple IAPP conferences this year. The security and privacy conferences have really exploded, and I think there's some interesting content there.
Sure, I've always, that's one I've eyed and thought I would love to go to sometime. So it's on my radar for sure.
Very cool. Well, Doug, hopefully I'll see you at one of these in person here soon.
Indeed.
So jumping to the next one. Now, this is one that seems relatively, I don't know if ubiquitous is the right word, but prevalent through all the surveys, in the sense that it's one that I think is going to be on every eDiscovery Today survey as long as you're doing them. It'll be on there in some form, but it's the use of predictive coding technology. I think that since the dawn of predictive coding and the Silva Moore opinion, when we thought there'd be a flood of utilization of predictive coding and related technology has really kind of ebbed and flowed in interesting ways. I think that the use cases have branched off significantly, but in terms of overall adoption, I think there's been some interesting trends. What did you find from this part of your survey in terms of the adoption of predictive coding?
So this is one of the questions I've asked the same way all 3 years.
Okay.
And it is what percentage of your cases utilize predictive coding technologies and approaches. So, TAR 1, 2, PAL, et cetera. And this year, 29.2% of respondents said they used predictive coding technologies in all or most of their cases. More than a third, however, 35.4% said they use it in very few or none of their cases. And only 42.1% of respondents uses predictive coding technologies at least half the time. So less than half the people use it half the time. Now, one of the things that's interesting is I asked the question the first year, and when I asked the question the second year with a bit broader group, going from 183 to 281, the percentage that used it all or most went down, and the percentage that used it little or none went up. It actually regressed from the previous year. This year, it was a slight progression again, but not back to the first year. So one of the things that tells me is last year when I explained the results, I said, well, the broader you go, probably the less likely people are to be using predictive coding. This year we were broader and had a little progression. But I guess what we're finding is that there's still a lot of people not using it a lot. They might be using it some, but they're maybe only using it for certain cases, not necessarily most or all of their cases by any means. And there could be, there were certainly in the thought leader observations, some thoughts about that and what it would take to change that and get more people to use it. But I definitely think that's one of the things that is interesting is there's still a lot of people out there that really haven't embraced TAR.
Do you think it seems like two of the groups that are embracing it the most, one probably because they sell it, it's part of their business model and they develop it, and one because when you do adopt it, and if you drink the Kool-Aid, it can significantly enhance your practice, would be in the former category providers and service providers and the latter law firms. Do you think that one of the potential drivers to increase adoption could be or should be more of an alignment between those groups to evangelize this to the corporations that of the benefits of its utilization?
I think there's a variety of considerations. Certainly, law firms and providers were a little higher than the average in terms of their usage. But yeah, corporate was way down. And you would think that corporations would probably be, I mean, they might be the biggest benefactors in terms of the efficiencies of it.
Sure.
But they don't seem to, they haven't embraced it. And law firms, I think they're a little bit above the average, but not tremendously above. And I think that's one of the things that is, you're still finding a lot of people who are still, their approach is, it's keyword searching and manual review. And they're doing it on cases that they could certainly apply TAR to. Obviously, TAR is not appropriate for every case. One of the comments, I don't know if it was going to be one of the ones you were going to pick from the thought leader observation, but Derek Duarte of United Lex, he said he didn't think there would be an increase in the adoption of predictive coding because the data sources are becoming more variable, and collaboration apps, mobile communications, maybe our current protocols don't work so well with those. And that's certainly one of the things I've thought about as well. Another thing I think could be dampening the potential use of it is the move to the left of the EDRM. And if you are calling further left, you may not necessarily consider predictive coding on as many cases.
Right.
So I think those are a couple of things that could keep it more stagnant, which is what it's been the past 3 years. One of the great things about surveys like this is that interpreting the results is open to interpretation. I may have my thoughts about what they mean. Someone else may have different thoughts about what they mean.
Sure.
Certainly, somebody said, well, hey, this year we had the fewest people who said they don't use it at all, the fewest percentage of people, 7.4%, who said they don't use predictive coding at all. So that was a positive over the course of the 3 years. And I definitely think that's one of the things that is interesting, is it is kind of, it's not just steadily moving up, it's just kind of there, and it's kind of at the same levels. We're not seeing considerable progress in the adoption of it.
Well, I think you bring up a really interesting point about surveys in general, but really this survey, because we always talk about the eDiscovery bubble. The kind of came from the Sedona world and kind of emanated out as the bubble grew. But
Right.
I think that, as you said, as things kind of get wider, as your frame of reference gets wider, as your population of users gets wider, something that might look like a regression is actually just the pool growing, right? Which actually net is a good thing, because like you said, if you have 400 plus respondents, the fact that they're even responding means that they're interested in the topic, and might have a skewed or not skewed, but might have a different response that when you extrapolate that out to the industry at large might not necessarily correlate. But I would argue that in many ways it does, because eDiscovery has always been somewhat, I don't know if trickle down is the right word, but the core of the bubble, that has always been kind of a indication of how far reaching through the legal industry technology, eDiscovery, and related concepts extends. So as the bubble grows, that whole group grows. So I would argue that if next year the eDiscovery Today survey, let's say, is 1,000 people, and of those 1,000 people, the percentage shows a regression in terms of the overall percentage, but the numbers are higher, indicates more of an industry adoption of predictive coding. So,
well, certainly, yeah, it's a fair point. It certainly illustrates more of an adoption of eDiscovery, or more people who care about eDiscovery. And obviously part of it is getting the word out and more people being aware of the survey we do every year. But that's certainly one of the things I'm excited about, is every year the survey's grown in terms of responses. So I'm definitely hoping to get beyond that eDiscovery bubble, which is a great way you put it, to really much more of the legal industry as a whole, and really try to get a sense across the board there. And I'm hopeful that if we continue to see this survey grow year over year, we'll get to that.
I think you're already doing it, Doug. I mean, not to say that folks in corporations are never part of the eDiscovery bubble, because there's clearly some corporations and some of our friends and colleagues that have long been in the bubble that are corporate focused. But I think especially when you start looping in legal ops, their breadth of interest, the levers that drive their actions, I think are so different from your traditional eDiscovery attorney or adopter at a law firm, that almost by definition, they're not really in the bubble. They're almost too big for the bubble. So I think maybe that's an indication that the bubble is changing or growing. But I think your survey is already making great strides and extending out into, beyond that traditional eDiscovery bubble. If there's two quotes I could read, one, I had to include him. I guess we can call him the king of TAR, Judge Peck, who's now a senior counsel at DLA Piper. I circled his first time I read it because I think his point about TAR is very, very important. The question asked is, what single development do you think would help further the adoption of predictive coding the most, and why? And I encourage everybody to leave a comment. What do you think would be the single most important development to advance the adoption of TAR? And also go back to the last topic Doug and I expressed, and what conferences do you like too? You can put those in the comments as well. But Judge Peck said more consistent court rulings favoring the use of TAR. For example, just after it looked like approval for use of search terms followed by TAR came a case that said that was not universally accepted. One step forward, one step back. And I agree with that. I think that there is some inconsistency, and I would implore everyone too to go also check out Kelly Twigger's comment about that very topic in the survey. I'm going to give you some little teasers to go to the survey. So Kelly has a great comment as well. Go check that out. But I think case law is important. Doug, what do you think about case law? Do you think that we need to have a more homogenous, if you will, jurisprudence around the use of TAR? Or do you think inevitably, because of just the difference amongst jurisdictions and cases, we're always going to have this plethora of differences amongst the opinions?
That case aside, which when Judge Peck responded with that response, we had literally, I think, just covered that case or just discussed that case, or at least I think I'd put it out there for us to review for the webinar that we do every month. That case aside, I think most of the cases have been approving the use of TAR and have been pro-TAR. But I think one of the things about that particular case was there was an ESI protocol in place where TAR wasn't contemplated. Then the producing party started to say, hey, we want to introduce TAR now. And the two special masters who were responsible for working with the parties said, hey, you didn't contemplate it here. The other side says you can do TAR, but not after search terms. We would want you to go back and do it at the beginning. So I think in that case, had there not been an ESI protocol or agreement up front, maybe there might have been a better chance for it to have been accepted. It was interesting in that ruling where the producing parties gave, I think, 4 or 5 case examples where TAR after search terms had been used, and the special masters picked out the 2 oldest ones and said, well, those aren't really relevant anymore. They didn't talk about the 2 later ones where it's been done. So I think it's one of those things where, yes, you would like to see case law more consistent, but far be it for me to disagree with Judge Peck. But I don't think that's the biggest issue. I think it's a combination of still people who don't really fully understand it and are afraid to embrace what they don't fully understand. And I think it, to some degree, can also be a disruption of the billing model and the concerns about that. And I think that's one of the things a lot of people don't necessarily talk about, but I definitely think that is something that some firms think about, in being short-sighted when really their customers should be demanding it. And if they were demanding it more, I know they would have to shift to that. And so that would be one of the things that I would say we would look to more of is will the end customers, the companies who are the parties involved, demand that efficiency for companies and firms to adjust their thinking?
That's actually an interesting point. So it's almost like traditionally CFOs at corporations haven't always been involved in the eDiscovery world, if you were, or if they do, it's tangentially with the cost, but almost like a top-down approach. Once the corporations really understand the benefit it could have, that might drive adoption a lot faster than updated court opinions. I think in terms of the trust issue, I see that as well. I see a lot of providers and firms trying to almost force getting over that. What I mean by that is in terms of discovery, the standard for discovery, right, is reasonableness. And I see a lot of folks saying that, look, you can't dictate to me how I discover documents. If I if I essentially certify discovery under 26G and everything's there, if you can articulate that there's a gap in discovery and I made a mistake, then fine. But until then, you just can't openly challenge the defensibility of my process if there's no other indication that it was done incorrectly. So I can do whatever I want. If I want to throw a box of documents into a room with 10 monkeys and just see what they pick, that's going to be acceptable as long as I can satisfy that criteria. And in that regard, I'm seeing a lot of folks that just use TAR at some level, or at least some level of analytics, whether they communicate it or not. I don't recommend that. I think any protocol has to be communicated and ideally cooperated upon. But I do see cases where folks are just doing it and saying, look, if you can identify I did something wrong, so be it. But in the short term, I'm going to use it.
Sure. But that actually, what you mentioned there does bring up one other thing that I think has been a barrier to the use of TAR is that, and Dr. Maura Grossman and Gordon Cormack, they wrote an article back in 21 called The eDiscovery Medicine Show. I covered it back when they wrote it. And they talk about the fact that there seems to be a different standard by a lot of legal professionals on what you have to prove when you have a TAR approach versus a keyword search approach. Whereas
Right.
keyword search, you don't have to do the testing and so forth to show that it was valid. People accept it as it is. And I've covered plenty of cases where keyword search goes just as awry as TAR can go. There's plenty of people who think they understand keyword search out there, but don't. But it doesn't get subjected to the same standard as TAR does. So I think that's what another factor that comes into play there is sometimes parties just were like, I don't want to have to justify my approach, discovery about discovery. I'm going to go with the approach that I know, people tend to accept. And I think that needs to change as well.
Definitely. You're definitely right that it's probably a factor of the kind of unknown aspects or the lack of education that TAR comes under higher scrutiny. I also think in many regards, and I know Sedona has put out commentary and there's been some public commentaries that address defensibility of the process.
Right.
But addressing the actual elements of the TAR protocol that would be subject to scrutiny upon which you could cooperate or you could collaborate. I think there's still a lot of unknowns around that just cause people to throw their arms up and say, look, I'm not going to use my client's active case to wade into these waters. I'm going to do what I know has worked for me in the past, and I'm just going to proceed with that caution. Here's a question. We just talked about the network or the neighborhood, the population, if you will, of users expanding. Do you think it's expanding to include people who are less sophisticated? Because I think there's a trend to think that the bubble's at the top and it all kind of expands from the bubble. But maybe it's expanding to include technologists, other sophisticated attorneys, people from different areas that are coming into the bubble already understanding or wanting to use this type of technology. Do you think that might be something that's happening?
Perhaps. I also think that we're starting to see some providers make the TAR workflows more intuitive and more like the workflows that legal professionals are used to using. And I think that's one of the things. Obviously, when TAR first came out, TAR 1.0, and you had to go through all these steps and have a training set and yada, yada, yada. It was not a very intuitive type process. And you felt like you needed a data scientist associated with every project and so forth. And now I think you're seeing platforms that are really, it's almost kind of like the way machine learning is working with Netflix and Spotify and Amazon, things like that. Behind the scenes where you don't even realize it's almost happening, but you're reviewing documents and based on your classifications of them, you're continuing to get better documents bubble up to the top of the queue until you just start running out of them. That's really, I think, what can make a difference in terms of people just kind of starting to embrace TAR. They may not even realize they're using it, but they're taking advantage of the fact that, hey, the application, the platform is giving me the documents or starting to direct documents to me that are the documents I should be looking at. And it makes sense to stop at a certain point when I'm not really seeing very many of those anymore. That's what I think we would hopefully get to. And that would be the approach that I think would include a lot more people from outside the bubble in.
And Doug, you talked about risk aversion. And one of the things I think that needs to change is in law, one of the biggest hallmarks of what we do as practitioners is you rely on precedent, right? And why do we rely on precedent? Really to mitigate risk. Did it happen over here? If that's the case, if applying the law to this set of facts brought this outcome, then ideally it would bring this outcome. But I think when it comes to the application of technology, there has to be some acceptance of risk taking. There has to be some acceptance of being creative. I think that we're not as creative as we could be in the application of technology because we're worried we're going to get smacked around by a judge. And I think maybe if there was a little bit of leeway, some more acceptance of things aren't going to be perfect. There can be errors. We're going to make mistakes. But if we're doing it in good faith with the intent to mitigate costs, to conserve resources, to get the best outcome for our clients, maybe that's something that should change too, is that, there should be a little more of a gray area where some errors can be made and you don't get in as much trouble.
Sure. Well, and I think also risk recognition. There's risk in staying in sticking to approaches that maybe are no longer as viable as they once were. So I think that a lot of people think that's the safe approach. But as you continue to move further down, and advancing in terms of the types of evidence we're dealing with and the volume of evidence we're dealing with and so forth, I think the risk eventually becomes greater to stick with what you're doing than it is to change. And so I think it's also a matter of risk recognition, and it's usually a factor that forces people to change. Just like the pandemic forced people to start using Zoom, we need a impetus to force people down that machine learning path of looking at doing it different ways.
That's a great point. It's a great point. So with that, we'll move to our next trend. And the next two questions that you ask or categories that we discuss are related to data types. The first is mobile data, and the second is collaboration data. What was the trend that you saw when asking questions about whether or not respondents are seeing more and more mobile data in their cases and whether or not that's flowing through their processes for discovery?
Yeah, a quick thought about both of those categories. The first year, I to be honest, screwed up, and I asked the question as a joint mobile collaboration app question, which really doesn't give you a good chance to evaluate either of them. So I learned from my mistake in that rookie mistake in my first survey.
But Doug, to your, just to give you a shout, I mean, when you first began the survey, what was that, 2019?
Well, it was 2020. Yeah, basically, yeah, released in beginning of 21. Yeah,
I would bet you money that if you were to look at the conference headers of the different sessions, everybody was lumping social, collaboration, and mobile all into the same discussion. So
that's fair. Yeah,
I think that was a common, I wouldn't even say a mistake. That was just a common trend during that time. So anyways, continue.
Yeah, absolutely. Yeah, we definitely, I think, are seeing them diverge in terms of the challenges and so forth associated with them. So with mobile devices, we saw almost a third of respondents, 31.9%, either always has or usually has a mobile device data in their cases. And not quite a fourth of respondents either never has or rarely has it. So almost half, close to half, 45, actually, I think it's 49.4% has mobile device data in their cases about half the time. So mobile device data is certainly, prevalent out there, reasonably prevalent. I think with mobile device data, the big question is proportionality. Mobile devices are still difficult to collect, and you have to go through those processes. Yes, we're finding some ways to make that easier, but that's still been a hurdle. And so what happens is you may have potentially responsive mobile device data sometimes, but you say the burden of it outweighs the potential value you're going to get from it. Interestingly enough, of course, corporate respondents are the largest group in terms of rarely or never having mobile device data. Over half of them, 54.1% rarely or never has it, and only 10.8% has it most of the time. And I think that's interesting in that corporations, they're dealing with data sources that are under their control, and mobile devices are typically BYOD devices in many cases, where they're not really in the possession, custody, and control of the corporation.
Right.
Even with a BYOD policy, we covered a case last year where the court found it was not in their custody and control. So it's not surprising to me that corporations would be a lot less on the mobile side than the other groups were. So
Right.
That's certainly one of the things I thought was interesting from the mobile standpoint.
To ask my own survey question of you, do you think that the fact there's a lower number of respondents that say they deal with mobile data, would that be, the answer is probably going to be D, neither one, Matt, it's this. But I was shocked that there was a comparatively low number of responses that stated that they have mobile data in their cases. As we all know, discovery goes where the data is, and we all communicate with our phones. So I was really shocked that that wasn't like a 95% or even 100% level response. But do you think that, at least from a majority standpoint, is the fact that you see the number of cases where there's mobile data is so low is because either outside counsel or providers are not scoping matters properly and they're not gathering that data? B, do you think that corporate policies are driving that, where they're really trying to prevent that type of data from even being created or generated? Or is it more along the lines of, like you said, because it's difficult to work with, are folks just kind of turning a blind eye and pseudo agreeing by osmosis or telepathy that we're not going to handle this, that it's unduly burdensome, and I don't want to ask for your phone data because I don't want you to ask me for my phone data? Is there an element of that, or is it something else?
So of the three choices, I've certainly heard that one being thrown out is sometimes happens, where they're just kind of saying, hey, let's agree we're probably unlikely to have anything that responsive in our mobile devices, so we'll just kind of mutually agree to stay away from those. I have heard that happen at times, talking to people in the industry. I do think that from a corporate standpoint, again, I think they don't really have control of the devices. So I think that's one of the things that they tend to focus on is the data sources they have control over.
Sure.
So that certainly would explain why their lack of inclusion is so high. But yeah, I think it's a proportionality decision where they just consider the burden is too great compared to the value that you'll get. I will say certain cases are more likely to have mobile data in them. Like, for example, IP cases, they're always going to want to go after, IP theft. The person leaves the company and they want to investigate their mobile device and probably forensically image it and things like that. Whereas other cases, they don't feel like there's just a likelihood of there being any material data there. And you would have to kind of really illustrate, okay, there's going to be enough here that we want to go after the mobile device, or at least certain data within the mobile device, like the text message communications between parties or things like that.
I also think you're seeing a big surge, if you will, in investigations involving mobile devices, whether it's the SEC investigating off-channel communications in financial services organizations, or just internal investigations generally around employment matters or whatnot, IP theft. But I think we're going to see a lot more of that. Kudos to you and all of your thought leaders. I think the mobile device and the collaboration, both of the data topics in the survey, I would implore everyone to read every comment from every thought leader. There's an amazing diversity of opinion in those responses. The question being, what do you think is the biggest challenge organizations face today regarding discovery of mobile device data? And your respondents, Doug, go from everything from operating system to individual behavior to policies and everything in between. So I definitely would ask everyone to read those, and feel free to leave a comment. For those of you out there that are handling mobile device data, whether you're a sole practitioner or employment lawyer, or you're dealing with a mega SEC investigation, what are some of the challenges that you're facing when you try to collect mobile data? And with that, we'll jump into the second data category, which is collaboration data. And Doug, you said before that you thought you made a mistake by combining those two sources. What makes collaboration data? I mean, it's clearly a different data type than mobile data, but what makes it so different in terms of how we handle it in eDiscovery?
Well, so, I think one of the things, of course, that you're seeing where mobile device data is on the mobile devices, collaboration data, you can typically get from the cloud. But of course, the question is, with mobile devices, you really only have two operating systems. You have Android and you have iOS. With collaboration apps, you have all these different platforms, not just the main ones like Slack, Teams, and Zoom. You've got, all these other platforms for project management or this or that are also collaboration apps. We just talked about a case yesterday involving spoliation of data from Basecamp that they use for collaborating on reports, safety reports that the party failed to produce and ultimately was determined to decided was, spoliated and intent to deprive. So I think the one of the things about this category is there's so many out there, and you're going to have to come up with a plan to address them. If you think you'll have discovery, there's collaboration and communications in these different platforms. You need to figure out how to handle them. The one people talk about the most is Slack, and Slack has a discovery API that helps facilitate it. But again, the level of integration with a platform also makes a difference too. Are you just simply collecting it and packing and then kind of just dumping out the messages? Are you doing something more that really gives people an understanding of how it's being viewed and used in the work environment? And so I think that's a factor as well.
There's also that factor you mentioned about mobile data, about how corporations kind of push it off because of the possession, custody, and control elements. Whereas that can't happen with collaboration data because the corporations onboarded these tools as a response mainly to the remote work trend that we talked about at the beginning of our discussion. So, this is something they really, really have to deal with. But do you think there is a gap, if you will, between the onboarding of collaboration tech? Because again, it seems like a lot of corporations had to make these decisions quickly because they needed to have their workforce mobilized and working together.
Right.
Do you see a gap between folks that brought on these tools and whether or not they were properly slotted into their information ecosystem for discovery projects? Is that becoming a problem, or in your experience, did most people think about that when they were bringing these tools on?
Oh, I'm sure a lot of them didn't think about that. And we saw a couple of really significant Slack cases this year involving spoliation and issues with discovery of Slack data.
There's one that you talk about, one of your factoids that, again, everyone go to the survey and check out. Thinking of reducing your Slack retention period to 7 days within a reasonable expectation of litigation. This case shows you why you shouldn't do that. So yeah,
Right.
I imagine a lot of folks, I tend to think the best of people. So I doubt that was probably something that was done nefariously, and more just because they didn't think about it.
Well,
right?
they did get let's see, I can't remember on that case if I think they got adverse inference sanctions. So they definitely determined it was intent to deprive. No, it was a case where
I just told on myself that I didn't read that case.
No, that's okay. That's all right. They determined that clearly they knew that litigation was imminent or reasonable anticipation. And what they had the archive, they changed the retention period to 7 days, and they deleted what they had downloaded. So they then they didn't change off of 7 days for quite a while. So yeah, I think again, it's one of those deals. I think people almost kind of treated discovery of collaboration app sources as an afterthought. I mean, the Red Wolf case where there was the smoking gun communication, when you've got two defendant founders where one says, hey, you think we should, it's an IP case, and one says, hey, you think we should develop our own algorithm to get these guys off our back? And the other one says, well, if you mean one not derived from IP, I think we should. I mean, they're like literally admitting they stole the IP in a Slack communication. And they're thinking no one's ever going to see that. So that's the type of thing that I think you're seeing is some of these communications are shifting to these other platforms that are highly discoverable and highly relevant. And so, yeah, I think that's organizations have to have a plan for them.
Yeah, and I think that dovetails beautifully with the ever evolving nature of the duty of competence, right?
Mhm.
And not just beyond, comment 8 to ABA model rule 1.1, but just the nature of being aware and on top of developments in technology and its application. We often think about that in terms of predictive coding or how to use technology to better prosecute cases or help our clients. But really, it's also, if I'm in-house counsel, my duty of competence is more than the use of technology to benefit shareholder value. It's more about understanding that if my IT team is onboarding new stuff, how can that potentially create discoverable information, or at least information that I have a duty to preserve? Because I think that's where you kind of create the most exposure. So I think really expanding the notion of what it means to be competent in the digital age as a lawyer, I think is really important. And you bring up a really good point with those retention cases.
Sure. Oh, and I also would throw out, not just the IT team, but there's a lot of shadow IT going on where different departments of an organization just unilaterally start using a platform because they can and because there's not a policy to really to keep them from doing that. There's plenty of companies that use both Slack and Teams, or Teams and Zoom, or maybe even all three, and so they're all discoverable. And you've got to have a plan for them. I will say that one of the things that's interesting about this category is that this is one where corporate respondents are in a big way. Nearly half of corporate respondents has collaboration app data in all or most of their cases, 47.4%. So that's pretty interesting because obviously that's a corporate data source, and they are seeing a lot of requests for collaboration app data. And we're seeing a lot more case law involving collaboration app data. So I definitely think that's one of the, it's no wonder so many companies are talking about, you got to handle collaboration app data. The trends are showing that we're getting these requests for them.
If I can really make a leap too, we talked about the drivers behind adoption of tech. One thing I think that can drive this is typically in no shade to any of my regulator friends, but oftentimes historically in the tech bubble, we think about regulators being behind the ball when it comes to tech. But like you just said, as requests for these types of data sources become more prevalent, the parties have to get up to speed. And one interesting thing, because the EU, the European Commission, is maybe a little more ahead, if not a lot more ahead of the kind of regulatory trends in terms of how data is managed and handled and addressed up front. Through the GDPR, you see a lot of communication back and forth. The US is now very much looking to the EU, to some of the regulatory trends and what they're doing over there, especially with some of the new artificial intelligence regulations, and really the digital agenda that the European Commission's putting in place. I think that's actually driving US regulators to get out ahead of this stuff. So I would say a trend you're going to see is maybe regulators getting smarter with how they ask for this type of data. And maybe that will end up being the biggest driver for corporations to finally get their arms around this.
Maybe.
I know that was a huge
No, that's a fair point. I mean, after all, EU, obviously GDPR came into effect in 2018, and then now some states have started to enact data privacy laws here. So yeah, absolutely, EU is a driver of that sort of thing from a regulatory standpoint, a data privacy standpoint, and I think it does impact things. It is interesting, though, that I think a lot of people are expecting that corporate communications will eventually be very collaboration app centric and a lot less email centric. And certainly that trend from corporate respondents this year seems to indicate we're heading that direction.
Wow. And usually I never let a question go unanswered, but there was a question I garnered from the survey that I'm just going to put out there for the comments. Are collaboration communications business records for purposes of litigation? That's going to be my question. It's actually probably Doug. I think I might have stolen that from you, Doug, but
I don't know. But I
So
think a lot of people are asking that. So I think it's a great question.
we're going to move on now to the next category in the survey, which is a new question that was asked of respondents, which is involves use cases for discovery. Doug, what were some of the trends you uncovered around eDiscovery use cases?
So this was a new question this year, and the question asked was, to which use cases do you or your organization apply eDiscovery technology and workflows today? And I've been saying for a long time, eDiscovery isn't just about litigation anymore. So I was interested to see just how many other use cases would score. And as it turned out, I think we had, I think it was 7 use cases that over 40% of respondents said they apply eDiscovery technology and workflows to. So in addition to litigation, of course, which was high at 96.3%, you had investigations at 83.2%. You had arbitration at 50.5%, incident response 47.8%, privacy request 42.4%, government information request 48%, and HSR second request 42.9%, and a couple of others close to the 40% mark. So it's clear that eDiscovery is being technology and workflows is being used for a lot more than just litigation and even investigations today. It's being used across the board, which is one of the things I think illustrates why it really eDiscovery applies to just about any organization today, regardless how much litigation you have.
I thought the most interesting use case is the utilization for data subject access requests. I really like the use of eDiscovery technology in that regard. But were you shocked that the litigation use case wasn't 100%? Maybe not every respondent was a litigator, but
that I was a bit surprised. It was pretty darn close at 96.3%, but maybe so there's, maybe again, we're broadening out in the industry, and maybe some of the people are using it for some of these other things more almost exclusively. And that's okay. I mean, we may have had some investigators there who you have used it almost solely for investigating. So who knows? But yeah, I think it is interesting that not everybody's even using it for litigation.
And a lot of the thought leaders in those responses talked about internal investigations. And also it seemed like a big use case trend was utilization of eDiscovery tech in the cyber realm with regards to a cyber breach and related issues. So moving towards the end, the next question related to the biggest eDiscovery trends of 2023. So a little bit of a future leaning question for this. Was there anything that surprised you about this question when you got the responses?
Honestly, it's been very consistent over the 3 years. For the 3 years, discovery of collaboration app data has been identified as the biggest eDiscovery related trend of the coming year. So this year, it happened to be the largest percentage ever. 38.5% of respondents tapped it as the biggest trend out of, I think it was 9 total choices. Second was AI technology at 16.6%, and 13.2% said increased use of cloud-based eDiscovery solutions. And I believe those have been top 3 pretty much all 3 years. So it does illustrate again that those are still areas we're pushing towards in terms of, even though we're seeing a lot of adoption of eDiscovery being applied to collaboration apps, a lot of people still think we have quite a bit of ways to go there.
And I encourage everyone to read that section. That's a really interesting section. Doug, if there's one category, we talked about you had 8 categories for this. If there was one that you could have added to the survey, or knowing what you know right now in this second would add now, what new category in Chat GPT discovery of that data is off the table? The most obvious answer. What category would you have added to the survey if you could?
I'm not sure that with the next question, I think there's 1 or 2 I think I'm going to start taking a look at adding. With this one, I'm not sure yet. One of the things I do think will be a coming trend that may be a year or 2 away, but I do think that discovery of things like blockchain, NFTs, metaverse type data is going to become more of a reality. Blockchain is one I think is starting to become sooner rather than later, because you've seen something like 8 cryptocurrency exchanges go bankrupt. Of course, FTX was very highly publicized. Litigation has arisen out of that one. And certainly, I think that's going to involve discoverable blockchain transactions. And, that's going to be a way different data source than all these others we've talked about. So I'm not sure about this year or next year, but at some point I could see throwing that in as an eDiscovery related trend to look.
And you inadvertently gave a shout out to a former podcast. For those of you that are interested in the legal issues that surround NFTs, you can go to the channel and check out the video with Lewis Cohen, where we talk about all the things as a lawyer you might want to like to know about NFTs, at least from a 101 standpoint. And with that, Doug, moving into the last trend, which I thought this one did make me laugh, but I think it's probably the most obvious answer. The eDiscovery challenge not being talked about. Was there any doubt in your mind that competence wasn't going to be one of the biggest answers?
Yeah, well, it's lack of eDiscovery competence has been identified as the top eDiscovery challenge that's not being talked about enough for the third year in a row. Interestingly, though, it wasn't as high a percentage this year as last year. Last year was 30% of respondents. This year it was 23.4% of respondents. So it was a little bit more even across the 10 choices we had in that instance. And so it's certainly one of the things that I think is still an issue. We're beginning to talk about not talking about it, so maybe it will move out of being the top one. Actually, Legal Tech News just published an article about lack of eDiscovery competence and cited the survey. Just published that today. I do think that is one of the things that may start to shift. I think one of the things that this may be a question I may change up a bit in future years. I think kind of an access to justice, pricing, availability, those types of things, I think are some of the things that maybe for smaller firms, eDiscovery technology may seem out of their reach in some of those instances. So that may be a couple of the things I try to look for next year. But certainly that particular category, eDiscovery competence or lack of eDiscovery competence was at the top. I think in-place indexing and the move to the left of the EDRM model is nearly doubled from last year to this year, moving to 15.4%. So I definitely think that's a trend that a lot of people are beginning to talk about, and I would expect a lot more chatter about it in coming years.
And that's when we talked about folks coming into the fold from other areas than just kind of the eDiscovery bubble trickle-offs. Is you have a lot of information governance professionals who never were involved in eDiscovery who are now jumping in from the left. So I think you're going to have kind of these bookends where there's an approach that isn't just eDiscovery professionals shifting to the left, but also folks that have lived in that space for a long time, now getting more involved with the larger eDiscovery world. What I thought was really interesting was the question of what is the eDiscovery challenge not being talked about. You saw corporations being focused on security, firms and consultancies really focused on that lack of competence. And I think maybe firms thought that because they're kind of in the middle, they're dealing with difficult corporate clients and maybe providers that aren't up to snuff they need them to be. And then service providers, though, and to give a shout to my brothers and sisters at service providers, who we don't often get the shouts, their biggest topic was discovery of collaboration data. So I made the correlation between the fact that the biggest trend people thought of for 2023 was collaboration data, and the biggest thing that wasn't being talked about by providers was collaboration data. So, hey, maybe service providers are a little bit ahead of the game on this one. So
maybe this is the first time that not all of the groups said lack of eDiscovery competence was their top choice. Law firm respondents were selected in the big way, 35.4%, but corporate, it was tied with increased cybersecurity, and providers didn't even have it in their top two, lack of eDiscovery competence. They had collaboration app data and in-place indexing. So yeah, it's kind of, and I hear plenty of providers talking about lack of eDiscovery competence. So that was interesting that they're thinking, oh, okay, well, yeah, it's the top, it's in there, but we're not talking about collaboration app data enough, which surprises me because it seems like we're talking about it plenty. But hey, that's one of the things we do the survey and we take a look at the results, and I think they're always intriguing.
So with that, and again, Doug, I cannot thank you enough. Thank you, for joining me on my, I guess, relaunch, if you will, but also one of the things I love about the eDiscovery industry is the academic arena, if you will, and all the thought leaders that really invest the time to push this industry forward. And to be honest, and again, not to blow smoke, I can't think of anybody who does that more than you with how prolific you are in your contribution to the industry. I personally want to thank you, and I know all my viewers likely do as well. But everybody, please go to eDiscoverytoday.com, where you can see Doug and his team's daily posts and a whole host of other resources. But Doug, as we close out here, A, what do you want to tell our viewers in closing? And B, what can we expect from eDiscovery today? Is there any big project coming up in the near future we should be on the lookout for?
Well, a couple of things. We just released a new white paper, practical applications of eDiscovery rules, where we talk about real case scenarios and apply them to the rules. So we actually, it's not just here's the rule and what it is. Here's a case or a eDiscovery disaster, what have you, where the rule comes into play. So it's designed to be something that can really put some real applications, practical applications to those rules. So that's just been released. Certainly, obviously, we are continuing to provide daily eDiscovery trends, best practices in case law. And I will say that with regards to this survey, that report that I just mentioned, and all reports and white papers that eDiscovery Today publishes, they're all free. All you have to do is subscribe to eDiscovery Today by email. Go to eDiscoverytoday.com, go ahead and click subscribe by email, and you'll get an email with links to all the reports we currently have, and you'll get links as we write any new reports or white papers. So it's one of the things that we do for our readership to thank them for being subscribers.
That's wonderful. And Doug, I look forward to seeing you at Legal Week in person. And I'm a subscriber to eDiscovery Today. I encourage everyone out there to go who's not already subscribed and subscribe. And one thing, if I can end, I can harken back again. It's amazing how the brain works. Doug, I think you inadvertently named the screenplay that you and I are going to write for our new series on Netflix called Shadow IT. I think there's something, there's something in there that we got. There's some magic in there. But
that would be a good title.
And with that, I want to thank our guest today, Doug Austin. Doug, thank you so much for being here.
Thanks for having me, Matt. This was a lot of fun.
Fantastic. And with that, this is Matt. And I wanted to say, all of you out there, please stay safe in the electronic wilderness. See you next time.
Bye, everybody.
And we're good.